and welcome to this episode of IP Cast, a podcast on IP-related matters by Starks, a niche law firm specializing in intellectual property law and international trade law. My name is Maria Bajtsova-Wenans, and I'll be your host today. Previous episode was a short one, so now back to a longer form for a change. Today, let's discuss graffiti from a copyright perspective. A famous graffiti artist, Banksy, never admitted he's an author of his artworks, except for the book Wall and Peace. There, on the intro page, he does claim authorship. I'll quote what he's saying. Against his better judgment, Banksy has asserted his right under the Copyright, Designs and Patent Act 1988 to be identified as the author of this work. To remind by this work, he means the book, not the graffitis. But can graffiti artists enjoy copyright protection? Should those street vandals damaging properties belonging to someone else have any rights? Let's discuss. In their research paper, The Piracy Paradox, Innovation and Intellectual Property in Fashion Design, authors talk about the so-called intellectual property's negative space. This concerns industries which involve substantial creativity that are either unregulated or only partially regulated by actual IP law. Put differently, IP's negative space is the territory where IP law may regulate, but does not. This is clearly the case for graffiti. Before I elaborate on the legal problems surrounding this matter, I would like to clear out some definitions. On many occasions, the term street art is used synonymously with graffiti, yet that's not entirely correct. When it comes to street art, legally speaking, these are artworks which have either been commissioned or just allowed. In case of graffiti, it is the result of an illegal act, and that's a big difference. While it is tempting to claim that only legal street art deserves to be awarded copyright protection, this would neither be true nor would it follow from the spirit of copyright laws. To think about it, copyright by definition protects original works fixed in any tangible medium of expression. Nowhere in copyright laws will you find a requirement for legality of such fixation. Moreover, the spirit of the copyright protection is rather geared towards promoting the artistic expression rather than limiting it. And that clashes with other laws, of course, especially those within the criminal or property field. So if we talk about the relationship between the graffiti artist and the property owner, it might seem obvious that the former has violated the rights of the latter and should be punished criminally or at least administratively for this wrongdoing, irrespective of whether it's regarded as art or not. On one hand, that's true. However, an issue arises if the graffiti artist in question is someone as famous as Banksy, and the owner of the property, instead of wanting to clear it, is eager to sell and earn quite some money. It becomes even more interesting when there are other beneficiaries coming into the spotlight. Consider the case of already mentioned Banksy. His work Slave Labor, made on the side of a shop in North London in late 2012, miraculously ended up in an auction house in Florida. What followed were protests of Londoners claiming that this piece of art should never have left London. It was indeed returned, though just to be eventually sold for $1.1 million at another auction. Banksy did not receive anything from this deal. To be fair, he also never claimed authorship of this work, although it was unequivocally attributed to him by art experts. Thus, is it actually fair that someone creates an admirable piece of art, even though illegally, and someone else gets money for it, way exceeding the possible repair costs of this, so to say, damage? Another case, Tierney, known for his vandal eyes, versus fashion mogul Moschino, incorporating this artwork into his fashion line. One cannot forget that street culture remains a very attractive field for a lot of people. Street, so to say, credibility might result in enhanced sales figures. But knowing this, can it possibly be fair to use graffiti without permission, recognition, and due compensation to create a fashion line? Wouldn't it result in potential confusion on the part of consumers as to the origin of the goods in question? Yeah, okay, this term comes from trademark, so not really applicable. However, above all, this is also the case where someone else benefits from the creative genius of another person. The Moschino case is not a sole example. A Whole Sniff's Glue versus American Eagle Outfitters is another one. The latter, as the company targeting mostly teenagers and young urban adults, chose to feature a Whole Sniff Glue's murals in its marketing campaign. Notable about that campaign were the models imitating graffiti artists. It seemed like they were the ones making the artwork. Even more, at the opening of the new American Eagle Outfitters store in Colombia, the company recreated the artists' murals in an indoor mall and put the company's logo over them, which is essentially stealing authorship. There's also another dimension to possible violations of graffiti artists' rights. Consider the case of Brazilian artist José Carlos Martina, who removed some graffiti from walls in the city and offered them for sale at a gallery. This act of, as it was called, vandalism against vandalism, was fiercely objected by the graffiti artists affected. Their response was the destruction of their own works right at the gallery where Martina exhibited them. Who is guilty here? And guilty of what? Sometimes the legal issues are even more complex as they go cross-border. At the 2008 Beijing Olympic Games in China, the Spanish synchronized swimming team wore swimsuits reproducing a German graffiti artist Cantwell's artwork. Here the question arises not only if and whom to sue, but also where would that be possible? Now, talking logically. First, classic copyright encompasses moral rights and economic rights of the author, and one can exist without the other. That means that there is no inherent problem with the entitlement to certain moral rights, while having no claim over the economic ones. Second, owning a copyright doesn't equal owning an actual copy of the work. Thus, the fact that the wall belongs to the property owner doesn't mean that he possesses also the copyright, especially not the moral rights. It goes also the other way, as graffiti artists cannot just by virtue of having moral rights of an author have any rights stemming from the property right. Third, while the right of attribution in case of graffiti, as illegal artwork, is in a way waived by the graffiti author himself, it cannot mean that somebody else can just claim the authorship for something that he or she hasn't created. Basically, in the graffiti artist versus property owner relationship, it seems logical that such rights as, for example, the right to display or even the right to destroy the graffiti would be vested in the property owner rather than the graffiti artist. Questions do arise with respect to, first, the right to sell and more precisely to the compensation, and second, to whether the destruction of graffiti would require a good faith attempt to notify the author. The latter stems from a Visual Artists' Rights Act in the US, but to the best of my knowledge is not mentioned in other copyright acts. As to the compensation, once again to the best of my knowledge, it is only under the UK artist's resale right that graffiti might, yet not unambiguously is, might be the subject of royalty on the net purchase price of the work sold. Of course, any compensation claim requires proper attribution, while asserting authorship might result in criminal or at least administrative charges for the author. Thus, for a graffiti artist, it is truly a thin line to walk. Nonetheless, while there's more clarity as to the issues arising in graffiti artist versus property owner relationship, things get complicated when it comes to third persons. Taking pictures without permission and attempting to profit out of it, or incorporating graffiti in a fashion line, or removing the piece with the intention of selling it while not being the property owner, all this, in the spirit of copyright, would constitute an infringement. At the same time, in the absence of clear legal provisions and case law, all this is also not so straightforward. To note on case law, while there are plenty of cases all around the world, a majority of them ended in settlements, thus cannot be really used as precedents to refer to. Either or, graffiti is a thriving creative field with lots of admirers, which on top of that becomes a valuable commodity in the modern art market. Therefore, there are plenty questions pertaining to IP rights and entitlements that cannot be just left to logical deductions and assumptions alone. There is a need for legal clarity. As a final note, some of the artists, like world-famous Kit Haring or Oz Guimeos or Jean-Michel Basquiat, just to name a few, started by creating their works illegally. Yet all of them switched sides with time and continued their artistic route by creating truly world-renowned and perfectly legal artworks. Thus, the question is, wouldn't the GUIP protection of graffiti also incentivize more artists to switch sides? That's it from me for today. And I guess this will also be the last episode before the summer break. We'll come back with more episodes in autumn, so definitely stay tuned. Subscribe, follow us on social media, and have a great summer or winter in case you happen to be down under. Thank you very much for listening. If you liked this episode, please show it some love and please share it with your colleagues and friends. As always, for any questions, suggestions, comments, and concerns, our email address is info@starks.be. Starks, your sustainable growth supporter.